Who are you speaking with? The flesh and blood man with a name? Because that's what I'm trying to find out right now, Judge. Who are you speaking with? The name entity or the flesh and blood?
I'm speaking to the person that's talking to me right now.
I demand to be released on my own recognizance. Who are you trying to conversate with? The name entity or the flesh and blood man?
When I talk, you listen.
Today we are looking at another intense courtroom episode involving claims often linked to the sovereign citizen movement, and this session quickly escalates into a tense exchange. The first defendant refuses to provide his legal name, and instead identifies himself as an entity while attempting to reject standard courtroom procedure. His approach immediately creates friction because courts require clear identification to proceed with any criminal matter. Rather than engaging with the charges directly, he challenges the structure of the process itself and speaks as though established law does not apply to him. The judge remains focused on procedure and continues to request basic information necessary to move the hearing forward. As the exchange unfolds, the gap between recognized legal standards and the defendant's personal interpretation of authority becomes increasingly clear. The atmosphere grows heated as patience is tested and order must be maintained. This case highlights once again how quickly proceedings can intensify when foundational rules are questioned inside a formal court setting. Stay with this breakdown as we examine how the judge addresses the disruption and steers the hearing back toward lawful procedure and accountability.
Hold on. Mr. Strickland, can you hear me?
I don't need to.
This is the judge.
Okay, Mr. Strickland,
Open the door.
can you hear me?
Can you hear
Oh,
him?
you don't want to hear me.
Sir, can you hear him?
What?
Mr. Strickland, this is
All right.
Magistrate William Burden. Good morning. I'm going to ask you a few questions. Do you want to speak with an attorney?
Who are you speaking with? The flesh and blood man with a name? Because that's what I'm trying to find out right now, Judge. Who are you speaking with? The name entity or the flesh and blood?
I'm speaking to the person that's talking to me right now.
I am executive of the name entity. That's who you're talking to right now. Do you understand? I am the executor of the name entity. I demand to be released on my own recognizance. I have right here, Judge. You see this, Judge? And then I also have a UCC1 in the name entity. So y'all trying to run a lien on the name, that's illegal. Who are you trying to conversate with? The name entity or the flesh and blood man?
You
I
tell
demand
me.
to be released on my own recognizance. I have a UCC1 here. I've laid claim to the name entity through the Secretary of State and the federal government. Here it is right here, the Secretary of State, just
Okay. Sir,
it's right here, Lincoln. To the flesh and blood man or the name entity. I'm trying to ask.
Sir, whether I'm talking to the flesh and blood or name entity, I'm talking to both of y'all at the same time. Do either of you want to speak to an attorney?
No, sir.
Okay.
And I don't consent to an attorney. I don't consent to be in no hearing.
Sir, I just asked you one question. I just need one answer.
And I don't consent.
Okay, I know that.
So who are you
Okay.
speaking with? The flesh and blood man or the name entity?
I'm speaking to both of y'all. I'm speaking to both of y'all at the same time. How about that?
This judge continues to impress with sharp timing and controlled humor that keeps the proceeding grounded even as tensions rise. At the same time, the virtual courtroom format adds a layer of disorder that makes it harder to maintain structure and respect. Several defendants speak over the bench as if they are in an informal setting rather than a legal forum governed by strict procedure. The interruptions create confusion and slow the pace of the hearing, which places additional pressure on the court to restore balance. While remote platforms can serve practical purposes in business environments, the dynamics of a courtroom demand a higher level of discipline and immediate authority. Without physical presence, it can become more difficult to enforce decorum and ensure that each participant follows established rules. Some observers argue that in-person hearings naturally reinforce seriousness and accountability in ways that virtual sessions struggle to match. As this case unfolds, the contrast between judicial composure and procedural disruption becomes even more apparent. With that in mind, the focus now returns to the ongoing exchange as the court works to regain full control of the proceeding.
You can't. I
Now,
don't.
sir, I know you want me to release you.
Here it
Are
is.
you gonna let me talk?
Here. You
Are
see
you
it?
gonna let me talk? Sir,
Sir?
are you gonna let me talk? I got some questions for you.
I'm here without consent.
Put the paperwork down,
Don't
sir.
consent to this.
I know you don't consent to this. You want the court to release you, is that correct?
Yeah.
Want to release you, the entity, or the person in the flesh? Which one?
Flesh and blood man. I own the entity, so it's going to be released anyway.
All right, now.
For UCC1, everything.
If you don't, when I talk, you listen.
I am.
If you don't want to talk to an attorney and you don't want to be arraigned today, we're going to put you over to tomorrow. You understand that?
But we already been through this. I am the executive of the account.
Okay. Have a good day, sir.
After that first exchange, the level of confusion in the courtroom was hard to ignore, and the defendant's statements left many viewers questioning whether he truly understood the legal process or was operating within his own interpretation of reality. Now the focus shifts to an even more intense hearing involving another individual advancing arguments often associated with sovereign citizen ideology. This defendant adopts a dramatic tone and repeatedly claims a lack of understanding of the court's authority, as if that alone could dismiss a routine traffic citation. Instead of resolving the matter through standard procedure, she challenges the framework of the hearing and directs her frustration toward the bench. What could have remained a straightforward civil issue quickly transforms into a tense confrontation marked by raised voices and visible agitation. The judge maintains composure and attempts to guide the discussion back to the relevant statutes and documented facts. As emotions escalate, the contrast between procedural law and personal belief becomes increasingly pronounced. The session evolves into a striking example of how minor infractions can spiral when courtroom authority is openly challenged. With tensions running high, the hearing moves forward toward an outcome shaped by established legal standards rather than dramatic appeals.
Ms. Phillips, please state your name.
Shannon Phillips, the natural woman. On the record and for the record, and let the record reflect. Can you guys hear me? It's saying I have an unstable connection. Okay. Just making sure.
So on October 9th, defendant was found in contempt of court. So that still stands. Ma'am, you can choose not to have counsel if you want, but you need to understand that you can get up to 90 days on the contempt of court matter. Do you understand that?
I do not understand any charges. I only understand universal law and the right to live in peace and to live as I intend to.
But given that she doesn't understand,
Was never let in, just like now. You administering the trust without consent.
I'm not going to be.
I'm having a bad connection. It's going in
I'm
and out. I'm not
be
hearing nothing
releasing
you all
the
are
public
saying.
defender's office from this case because I don't think she fully understands the consequences of her actions, and so she will continue to have the public defender.
I don't need a public defender, Judge Washington.
Ma'am, I asked you a simple question and you did not answer the question in a way that makes me feel comfortable that you don't understand that you understand the laws of the state.
You all are speaking legalese. You all are speaking legalese. For me to say I understand the charges gives you all permission to administer the trust.
Okay.
I don't understand the charges.
Which is why you will not.
And I do not need counsel. I don't need representation.
Your request is denied, ma'am. You will have representation. All right. Mr. Lebo, do you know what your client wants to do?
Oh my goodness. This is
the charges.
You cannot make me have an attorney.
Well, actually, I can, ma'am.
Like, this is insane.
Well, I don't think it's me that's being insane.
The continued reliance on virtual hearings raises ongoing concerns about order and effectiveness within the courtroom setting. In this session, the judge often relies on sharp and composed responses to manage repeated interruptions from the defendant, which highlights the challenge of maintaining authority through a screen. The atmosphere feels strained as structure competes with constant disruption, and the usual formality of the court seems harder to enforce. At one stage, the judge appoints legal counsel in an effort to protect the defendant's rights and move the case forward within proper procedure. Instead of accepting that assistance, the defendant responds with open hostility toward the appointed attorney, yet no immediate sanction follows. The absence of visible consequences leaves observers questioning whether virtual environments limit the court's ability to reinforce decorum in real time. While remote access increases convenience, it may also reduce the sense of gravity that naturally exists inside a physical courtroom. The tension between accessibility and authority becomes a central theme as the proceeding continues.
I can handle my own affairs. I don't need your public defender. All I'm trying to do is get the case settled. That's all. This has been going on for so long. A waste of time and money, honestly.
Mr. Barnett, is there an offer?
There is an offer for the civil infraction and expired plate.
Your Honor, I'd be happy to go into a break-in with Ms. Phillips and explain that to her.
Okay, I will let you do that.
Thank you, Your Honor.
You're welcome.
Assistant Public Defender Davi Liebe on behalf of Ms. Phillips. Ms. Phillips, could you unmute and state your name, ma'am?
Shannon Phillips, the natural woman.
Liebe, where are we with this, please?
Your Honor, I did have a discussion with Ms. Phillips. I did attempt to explain the importance of representation, why the court has asked that she have an attorney in this matter, as well as conveyed Mr. Barnett's offer. Ms. Phillips indicated to me that she still opposes having an attorney. Additionally, indicated to me that she is not, at this time, wanting to accept the offer of an expired plate.
Well, I think the offer was for a civil infraction of something different.
I believe was the civil plate infraction.
Oh, I see. Okay. All right.
It's improper plate.
What was the offer again, Mr. Barnett?
It was the civil infraction of having an expired plate.
All right, thank you. And not the criminal, criminal infraction. Okay. So, Ms. Phillips, that's correct. You're rejecting that offer.
The offer of what? He didn't offer anything.
Ms. Phillips, he just told you that he's offering.
Am I not hearing something?
He just told you that he's offering you the civil infraction of expired plate as opposed to the criminal offense of expired plate. One carries.
Okay, but according to the Supreme Court, traffic infractions are not a crime. The people versus battle. So what criminal infraction? And I would just like for the case to be dismissed. One, because your who was it, Officer Hannah, and 3 more officers were surrounding my vehicle, pulling my door handles, threatening to pull me out of my vehicle.
Ms. Phillips, I'm going to advise
I don't even have the vehicle anymore.
At this stage, it becomes increasingly clear that legal representation would be in her best interest because she continues to reveal important details during the hearing that could significantly influence the outcome if the matter proceeds to trial. Speaking freely without guidance in a formal legal setting often carries unintended consequences, especially when every statement becomes part of the official record. Although she appears confident in her understanding of the process, the risks of navigating complex legal standards alone are substantial. The underlying issue began as a relatively minor traffic citation with a modest financial penalty, yet it has now expanded into a prolonged, intense dispute. What might have been resolved quickly through routine procedure has evolved into a drawn-out confrontation that consumes time and resources for everyone involved. Cases linked to sovereign citizen-style arguments frequently follow this pattern, where resistance to established authority complicates matters that would otherwise remain straightforward. The contrast between the simplicity of the original citation and the scale of the current conflict is striking. As the hearing continues, the focus returns to how the court will address both the procedural challenges and the substance of the violation under governing law.
I'll take that as a rejection of the offer.
Okay, so what's the offer? I didn't tell him anything.
Mr. Lebo?
Right, y'all just hate to hear the truth. Y'all just want to do what y'all want to do.
Ma'am, if you don't stop yelling out in court, you've already been held in contempt before. I'm going to hold you in contempt and give you 10 days in jail. Do you understand? Mr. Lebo, do you know what your client would want to do?
I do not, Your Honor. I did have a discussion with her, but she did not convey to me a desire to participate in that conversation.
All right. Then if she's not telling you, I will set it for a trial date.
Ms. Phillips, Your Honor, I would perhaps ask the court to consider a competency referral.
Nothing is wrong with me, you all. I am perfectly fine. I can handle my own affairs. Nothing is wrong with me.
I see you're doing so well so far. You're almost going to jail on a traffic offense.
And I do want to know that I did attempt to explain to Ms. Phillips why her understanding of the case law regarding traffic offenses was inaccurate, but that was not a productive conversation.
I could see why it wasn't productive. So I don't know that she meets the level of incompetence to the standard that you're indicating. That if you want a referral because you've talked to her and that's where you are, I will refer her for a competency. If she doesn't participate in that, then she'll be found in contempt or have to go to jail to get it done. So her behavior here today is obviously taking her down a very dark path. Hopefully she can change her mind and do something appropriate. So you either want to have a trial, ma'am, or you want to actually accept an offer. So those are your options.
We could take it to trial. We could take it to trial. We could take it to trial.
If this matter advances to a jury trial, the current strategy may present serious challenges for the defense because first impressions in a courtroom can strongly influence how testimony is received. Jurors typically evaluate credibility, tone, and consistency within moments, and prolonged arguments that stray from established law rarely strengthen a case. Her repeated insistence that she understands the system better than the court may come across as overconfidence rather than preparation, which can shape perception in powerful ways. Entering a courtroom with visible defiance often creates barriers that are difficult to overcome once evidence is presented and deliberations begin. Judges, jurors, and even observers tend to focus on clarity, respect, and factual grounding when assessing claims. As this situation develops, many will be watching to see whether the approach changes before trial or remains on the same path. If there's interest in a full analysis of the jury proceedings, that coverage can follow with detailed review of testimony, legal arguments, and final outcomes.